When the minister treats you bad and there is no appeal, don't be sad, you can still make him squeal. It's by judicial review, it's ultra vires, unfair or just plain dumb. The judge can say, hey minister, start again, you bum.
Hello everyone, I'm Neil, and today we're talking about one of the most powerful but often misunderstood tools in Irish public law, judicial review. What is judicial review? If a public body, a board, a minister, a planning authority, makes a political decision that affects you, you can't just say, I don't like it, I'll appeal it, because with most political or executive decisions, there isn't an appeal available. But you can ask the High Court to check whether the decision was made lawfully. That's called judicial review. Judicial review looks at the procedure that led up to the decision being made rather than studying the decision itself. The court checks legality, fairness, and rationality. It does not sit down to remake the decision. If the process was flawed, the court sends it back. If the process was sound, the decision stands. Why do we do it this way? Remember the separation of powers that is so fundamental to our Constitution. The legislature makes the law, the executive carries it out, and the courts interpret it. Courts do not run planning, immigration, or environmental assessments. That's for the specialist bodies. This is exactly the logic you see in O'Keefe versus the ABP, where the Supreme Court said, look, these specialist authorities have expertise that we don't necessarily have, so the courts will only interfere in limited and rare circumstances. Judicial review in Ireland is the High Court's power to supervise public decision-making to make sure the decision-maker stayed within their legal powers, followed fair procedures, and reached a decision that wasn't irrational. It is not an appeal on the merits. Who can apply for judicial review? Right, can anyone run into the High Court waiving a judicial review application? Sadly, no. Irish courts want to see two things before they will even let you stand up to argue your case. Speed. In many public law areas, especially planning and environmental matters, you must move quickly. Irish legislation often gives a very short window, commonly 8 weeks in planning, EIA contexts, to bring the application. This recognises the need for the process of government to be able to continue without being held up for long periods. In planning, it recognises the importance of finality for developers and of not dragging out big infrastructure projects. That's the policy background of which the courts are conscious. So if you're teaching or studying this, the exam-friendly test is, are you directly affected? Is it a public decision? Are you in time? If yes to all those, you may get in the door at least with a chance to deliver your arguments. And remember, judicial review is discretionary. Even if you prove a flaw, the court can still say it's not worth quashing. You will see the courts doing that often in challenges to a planning application, where the courts say, in effect, EU law must be effective, but it's not about formalism. That's exactly the message behind the decision of North Kerry Wind Turbine Awareness Group versus ABP, where McGovern J stresses the need for a balance between effectiveness and overzealousness. By the way, quashing is just a lazy way of saying squashing. When a law is quashed, it is squished to nothingness and put in the brown bin. What are the grounds for a judicial review? Now that I've jumped through all these hoops, it's time to have some fun. So, what can I actually argue? Breach of a statutory and/or procedural requirement. If the statute says you must do X before granting Y, and the decision maker doesn't do X, bang, that's reviewable. It's the classic ultra vires point. If you go outside the powers the legislature actually gave you, the decision is vulnerable. Irrelevant, relevant considerations. You can challenge a decision where the decision maker had regard to an irrelevant consideration or failed to consider a relevant consideration. This is explained by Clark J. in Sweetman versus ABP, where he says the court is duty-bound to look at whether the decision maker took into account things they should not or failed to take into account things they should. So, considered the wrong stuff? That's a problem. Ignored the right stuff? That's a problem. Breach of constitutional justice / fair procedures. With the two classic principles of natural justice, audi alteram partem, hear the other side, nemo iudex in causa sua, don't be a judge in your own cause. In plain English, what these principles say is that if a person is affected, they must have a fair chance to be heard before the decision is made. If the decision maker is biased, or even appears biased, the decision is vulnerable. Failure to state adequate reasons. This is an important and popular ground of challenge. Irish courts increasingly want decision makers to show their workings. If there are no reasons, or the reasons don't engage with the real issue, that can be a ground for quashing, breach of constitutional rights / ECHR rights / EU law. A challenge can be brought for breach of constitutional rights and / or rights under the European Convention on Human Rights, and for breach of EU law. This brings us to what can be called the proportionality analysis, especially where fundamental rights are in play. In Meadows versus Minister for Justice, Equality and Law Reform, the Supreme Court said that when an administrative decision affects fundamental rights, the court should assess it by reference to proportionality. Is the effect on the person's fundamental rights proportionate to the legitimate aim? Murray C.J. put it as requiring that the prejudice to the individual be proportionate to the legitimate objective. Denham J. said proportionality is inherent in reasonableness review. So the Irish position after Meadows is, we still have O'Keefe, but in Wright's heavy cases, the court will look more closely at the impact of the decision. Irrationality / unreasonableness. This is a tricky one, as it seems to ignore the previous concept of not looking at the decision, just the procedure. That explains why this is not often used, or more precisely, why it is not often successful as a ground for judicial review. This is where two of the most important Irish authorities come in together. In State Keegan versus Stardust Victims Compensation Tribunal, Henchy J. said the question is whether the conclusion can be said to flow from the premises. If it plainly doesn't, the decision is fundamentally at variance with reason and common sense. In O'Keefe versus ABP, Finlay, C.J. confirmed that intervention on irrationality is limited and rare. The court won't interfere just because it would have made a different decision or because the case against the decision looked stronger. The test is very high. The applicant must prove the decision maker had no relevant material before it to support its decision. I like to quote the English law on what is known as the Wensbury test. So outrageous in its defiance of logic or accepted moral standards that no sensible person who had applied his mind to the question to be decided could have arrived at it. That's legalese for you're batshit crazy. Students, remember this. O'Keefe still rules the roost for Irish administrative decisions, especially planning. But when EU law says the review must be effective, as in environmental cases, Irish judges have shown they can turn the dial up a notch without turning the judicial review into a full appeal. In other words, judicial review is flexible enough to meet the EU's effective judicial protection requirement.
What is the impact of a judicial review? So, what happens if you actually win? The most important thing to remember is that the court does not impose its own decision. No, it quashes the decision and sends it back to the body that got it wrong. That's because judicial review is about process control, not decision substitution. What usually happens, quashing, certiorari, the bad decision is struck down. Remittal, the matter is sent back to the original decision maker to be re-decided, this time lawfully. An injunction might sometimes be granted where the machinery of government is already in motion as a result of the administrative decision, and the court has to stop matters from proceeding further. For example, where a refugee has been served with a deportation order as a result of a faulty procedure. Sometimes the court may make a declaration or an order to follow the proper procedure. This is usually where the official involved has made a proper mess of the whole thing. Very rarely, the court might award damages, compensation. But the courts keep saying they won't usurp the role of the administrative body. Humphreys J. in Holohan versus ABP says, "Your decision is wrong, here's my decision." Then the court would be itself guilty of usurping power. Judicial review is designed to avoid that. So if you bring a review because you didn't like the outcome, I wanted planning permission, the board said no, the review court is not going to gift you your planning permission. But what the review court can do is make sure that the board, 1, had the power to do what it did, 2, followed the procedures, 3, looked at the right factors, 4, gave proper reasons, and 5, didn't make a decision that flies in the face of fundamental reason and common sense. And that's the real impact of a successful judicial review. The impact on the individual, you get another, fairer run at the decision. The impact on the administration, you're reminded to stay within powers, document reasons, and apply the right tests. It is also politically embarrassing when a minister loses a review. The impact on the legal system, we maintain the balance this video started with. The legislature makes the law, the executive implements the law, and the courts interpret the law. No branch steps on the toes of the other. So let's put it in one breath. Judicial review in Ireland is the High Court keeping public bodies inside the lines, checking legality, fairness, and rationality, using tests laid down in cases like State versus Stardust Victims Compensation Tribunal, confirmed and narrowed in O'Keefe versus ABP, broadened contextually in Sweetman versus ABP, made more rights-sensitive in Meadows versus Minister for Justice, Equality and Law Reform, and kept aligned with EU effectiveness in SIAC Construction Lilty versus Mayo County Council and the later planning EIA decisions mentioned before. Repeat after me. The court won't redo the decision, but it will make sure it was done properly. I'm Neil, and this has been The Law is My Oyster.
When the minister treats you bad and there is no appeal, don't be sad, you can still make him squeal. It's by judicial review, it's ultra-vires unfair. Or just plain dumb, the judge can say, "Hey, minister, start again, you bum." But what's the attraction, you might say? He'll just do it again. A bit different, but hurts me anyway. Well, that's the beauty of JR. It's politically embarrassing for a minister to take a shellacking. And so he will duck his head, put his tail between his legs. It's by judicial review, it's ultra-vires unfair. Or just plain dumb, the judge can say, "Hey, minister, start again, you bum."